no ama asase ho nsɛm ayɛ bibi kakra ho asɛm ne kan na pa enti sɛbi utimi gina yie ana wonya information bi land issues land information bi a etimi boa wo ma wonya ntease ne humui ɛwɔ nsase mu a ɛboa wo bebree ma wo nkɔ bebi enye sɛ wo nkɔ ma wo ntua sika enye sɛ wo ntua ma wonya ntease nso ma sɛbi obi tu anamon bi ma de ama wo bi nkrofo wo akwantuo mu US, Italy, London, wherever you may be, no. Mpempi no ye de adesua command nkrofo so omboae na me de omonso amboae ebi oseboa me na mento asase wo ha na di mikan ebi also kra yankasa ne etokra ententem na ese de ese se eba back ne ebe de ebe ye adwuma abrofo adwuma ese oba ntem enti we gya ye chi e de man nkrofo enti wankasa wantime anya ntiase wo nyeme ne bi hu na wantoto wachi ana wa hu se bebia wakofei ye wa asase wakọ akodi achire sebe sana mrane ka na se ne yehu no se bi na usika wada agye anidaso nso awa onim se wo page apade bi snow imu de aba be ye agya ma wo ma no na akoye de wonsa asifo monti eya mon kan hwe nkrofo na ye na ye nsua bibi mfemfiri mu na mgidi se ebeye emmo de ama ye nyina good. Let me say last week we started let me say na ye be kai kakra last week no me ka what in law no ye ka say emre bia no ewo adekro titiri a epese ye brofo no ye can say bia mischief that is to cure and I said the intent of the law na a law ne pese den etimi achieve na enum no normally in a long title mu na ye hunu and I say utimi say law bia ye man heading bi sa heading no tenten no na utimi hu botae a ewo law nature. Now, last week, I think I made sure say we should note about 3 key words. Now, words are now woman here revise, harmonize, and consolidate. In the mima, who abako sem kakra say, landlord, who emu fie who asem edwuma ewo ho enye ne nkwa ache kakra ache kra if we lap land administration project. And one of the byproducts of the land administration process was to get a law. It was to revise. Into to say in a course creation revise. That means idea or hodida. Near sign shemu. You shemu so I be a so way dear. And when he say besan ma I will loaning. And now wait here. And then here cry say than any say a cry a bebwa into revise. Now harmonize. Harmonize also the same them the two who send a go for bond to move Tony the because I wait and tossum. Obi so Tony the ultimate say we da ma uti nyum na eto wasum fefefe enti ta na mra na say e be say dey because any kind na various land department the agencies na dey na obi a won the law na odi dey odi na adwuma enti harmonize no say be say na be say we can say we so can say dey yi ni na mu kakra na be dey say dey e be say e be ko totin the see efa benkum a ye na efa benkum se see ekọ nipa so a ye na efa nifa so na me kan so say consolidate protocol mo say mo na kan consolidate say wo boa ni na no o man ni na nya fapem baako enti wo fa landlord na obehu section we various chapters ebi wo ho a it talks about land acquisition by the state ebi so to land registration ebi so kan survey for ho adwuma and at the end to say various laws na first agencies need the adwuma any akanin na bom na aye ba ko nti fa landlord na aye document ba ko no na sese hu won sase mu nyina na hu ya na asem ra sese ebo sase hu sem kita hu na ade nyina na de ukra ai be de ebitimi aboa wo bebre em say ne kenkan so last week no nem se me de na ka masumo a bepese baby ebese abomu de ho kakra no eye se fiti emrai enhyehyɛ no se no fi ni ho a be friend say freehold interest in land ye hwe 1992 constitution mu a na ema ho kwan say freehold no utiminya o stool land pem but say the a man say family land o, stool land o, won't mean ya freehold. Freehold no na mpempi na broche ye to asas ye koto dan a wonya no wo de kwakwa utimi tua mortgage wie nko ade a wo de a obetimi de ama onananom na kanso anom sabi untua rent mfa ma obi a utua property tax na wo wie nti na se wo de kwakwa wo ne obi a eni twaka bia obi mbeje rent obi mbeka se tina asasi so 2 years 10 years 20 years 50 years wo de afebo na me say bia yen Ghana se na yasetena ne tie nti no nti abai ne timi hu se ya mpempi no sika no yetua ya na akodi nipa ba akokutuku nti na kabota da freehold mu no ntimi aho amma yemfa so because sika yen Kenya ya na ka bia aboa school mu bia ko share investment mu a nkrofo a na asase ne omode no omonananom atimi anya bibia afiri mu but mpempi na ntisa am say na yese nipa ba ko japade o jisika kutu na odi ahye ne kotukum ene ka afofra na yese bia akoto na ade nti na kyese mfaso anka ebusueku no ana ebusue no ebenya no na amanesa nti abantimi hu say ye lease de na etesen ya so mo be kwa akoji lease rent ne nko ade a etesen ya sika ba futuo nim etesen ya sika ba futuo nim say yearly rent kakra moko round kakra jiji a sika beba futuo ni ma sebe ebi betimi ada ho a ahwima fo nso ebe de ebetimi de enya bi na hihye bi e wo ho a se de ma omo de ma omo it means a lease so it makes room for revision of rent normally 5 years and I be revise rent no say sika na bi wo ho na eso ate ho ahoden na den ebi wo na akofo nti revise the IBS rent na utu 100 Ghana cedis say maybe na e be say 150 and 200 na no na aboa because abi asase a wo je no 1990 and 1960 and I say etwemu no na ayese sika na ho de na akofom enti yentimi nya emfaso bia wo sika ketwa na yeden e wo wonsem ni mu bio but ye revise dia ana say lease dia ma kwan say revise nti na ho ade ho aba emfaso say no ne ade a mekai say hu behia say ye de betu etim ya na mmra bia so what time I take effect eno na ebi wo ho na brofo ye kan legislative instruments ebi wo ho na mmra kakra ebe che say we ni big law no but ene na che say yenye yenye b yenye c 2 weeks ye be say 3 weeks ye be say ana obe odi we beto ha odi fa we nto ha eno pensem mu kakra enti me share mu me encourage say obi a wo document abomoden na ko register bia there is a leeway now obetime nya interest na as a freehold no say na auto no akopim time a mmane be ne say de kete no obi entimi enya freehold interest bio ewo asase emu enti ebetua so those viewing and those listening on radio and then watching us on various platforms. I'm just trying to do a recap of what we may have learned last week. And I said that we looked at the long title of the law. And normally there's the long title which tells you why the law was made. As we say in the legal parlance, the intent of the law or what the law was meant to cure, mischief, the mischief that the law was meant to cure. And when we look at the long title, we see 3 keywords: revise, harmonize, and consolidate. And we all know what we mean by revise. You look through it again. What you think should be set aside is set aside. New things that ought to be looked at is looked at. And then harmonize, trying to make sure that there are no potholes, there are no more pitfalls or huge disparities. You get a level ground so that all the parties that are part of the law have a common ground upon which they all have an understanding. And then consolidate. As we all know, consolidate is to put together, to make as one. So as we said the last time, there are various chapters in the land law. A chapter can be talking about acquisition of the state, a chapter on land registration, a chapter on surveying, a chapter on stamping of documents and all those things. So when you take the law, it's a complete document that relates to all issues on land acquisition or legal matters in Ghana. And I remember that one important thing I said last week was that with the advent of this law, freehold interest in land is no more tenable. I mean, you cannot acquire a freehold interest in land again. The law debars it. And I made reference that in the 1992 Constitution, it was 2 lands that forbade the creation of freehold interest in 2 lands. But now the law has made it that whether family land or stool land or skin land, freehold interests have been what is no more. You can no more acquire an interest as a freehold in land. And I tried to offer some explanation that sometimes when the bulk amount or premium is paid, a lot of times maybe it goes into one person's pocket. So the purpose for which maybe that lump sum was collected from an individual who is acquiring a land, it goes into one person's pocket, and the family members, the children who are supposed to benefit from the produce of the land or revenue from the land, they don't get anything. They don't get anything. And you cannot go and ask the freehold person, the person who has acquired the freehold, that give us anything. No, there is no more agreement, or there is no more contract that I'm to pay you anything. And there is no duration of the lease. It's for perpetuity. So you cannot come and say 20 years time, maybe I want my land to do something. You cannot re-enter, you cannot do anything. It's for the person for the rest of his lifetime. And that is what mostly, those are the kind of interests that we have in the properties that we acquire in the various foreign countries that we are in, especially the US and in UK. You acquire freehold interest in the land, in the house that you purchase. So if you're able to pay your mortgage off, you are the land is yours, the house is yours, and it is yours forever. You pay your property rate and you are free to go. So I think that was the most important thing, as far as I would say, on the discussions we had last week. We talked about other things too. If you would remember that there are various terms for acquisition of land for poultry, for crops like cocoa, timber, and all those things. So we will continue today, and I think it's going to be interesting. And I just want to say that if there's anybody who would want to contribute, like I keep saying, nobody knows it all. A contribution, an understanding, a clarity from another person would also help. So those viewing, those listening, you can just come in, or mute your phone, or mute your mic, and then you can join in the conversation. If you have a question too, definitely please bring it on board so that we all come to a common understanding about what the issues are. Today we are going to discuss something that is quite interesting, and I wish there would be questions that will come up, or clarity, or further contributions, so that we will all enjoy the discussions that we are having. Specifically section 38, and I would want to read the provision and then try and explain it in a bit of layman's language. So I'm starting from 1, that in every conveyance of an interest in land, the expressions used to denote the parties to the conveyance shall be deemed to include their heirs, successors, personal representatives, and assigns, except insofar as a contrary intention is expressed in the conveyance or appears by necessary implication. So I think when you look at the old leases, you would find all these words, that it is binding on the contract that is entered into, whether freehold or leasehold. It is binding on the heirs, successors, personal representatives, and assigns. All those words were put in. But the legal drafting now is that it is not necessary. It is not necessary to state all these things. And that's when you go into the contract, once it is executed, it is deemed to be binding on those who are your successors, personal representatives. So you don't need to put all those things in it. If it is there, well, for some people it's clarity. But if it is not there, it is implied that it is a provision that is available to your successors, heirs, and your personal representatives or assigns. What you have, you can assign. What you had, your personal representatives can depend on it to administer your property when you are dead. If it is a will too, the executors are there. So that is it. You don't need to have all those words written out for it to be binding on those who take after you. And then when we look at the 38.2, it says, the persons expressed to be parties to a conveyance shall, until the contrary is proved, be presumed to be of full age and capacity at the date of the conveyance. This one, I think, it's basic English that we can all appreciate, that the person or the parties signing are deemed to be of full age and capacity. And I think in Ghana, it used to be 21, but now it's 18. So if you're 18 years, you can go into a contract. But I think what I would want to say about this provision is that sometimes a lot of people buy properties for their children. And the law is saying that on the face of it, nobody may ask if the person was of full age or legal age or had the capacity to execute that document. But when you go to court, everything is what can be contested. So the other party's lawyer can just look at the document and you standing there and say, hey, when I look at you 40 years ago, I'm not sure you were born. And that will throw the whole document as being fraudulent or invalid, because you are deemed to be of full age. But when it is calculated, the property was bought for you when you were a child, when you didn't have the capacity to enter into a contract. It will automatically bring an end to whatever arguments you may have had, and the other party will have a field day, and the contract or whatever lease or freehold interest you had will be nullified or cancelled by the courts. So please take note, so that your children should be of full age before you put their names or you make them signatories to the contract. Otherwise, acquire it in trust for them, so that when they become of full age, they can they can now have the benefits of it. Me aseɛ kakra sɛ section of the law na ɛkyerɛ sɛ yɛfa document bi a ntiaseɛ wɔ mu ne sɛ nkurɔfoɔ mu de wɔn nsa tintim aseɛ no nyinaa no, mmara mu no wɔn anyi a wɔn adwene da hɔ mmara kwan so sɛ wɔbɛtumi ayɛ dɛn tintim krataa no so, mmuie a ɛwɔ mu bia na wɔn anya ho ntiaseɛ. Sɛna aborɔfo yi mu na ɛka no capacity, sɛ wɔn ho tumi, wɔn ho ntiaseɛ sɛ ɔbɛyɛ dɛn ɔbɛsign saa document no, a contract no, as at the date of the conveyance. But mpɛn pii no sɛ ɛyɛ nkurɔfoɔ ɛtɔ nsase de ma wɔn mma. Obi wɔn di 18 no, nso na watɔ ama ne ba no wɔ ne ba ne din mu ɛna adeɛ. Obi ambisa ho hwee a mmara ne sɛ yɛfa ne sɛ onipa koro a ne din hyɛ hɔ no na ɔwɔ full age. As a legal age and maturity, sɛnea yɛka no wɔ Borɔfo mu legally no, age of maturity, majority obetumi ayɛ dɛn afa own property. But sɛnea yɛtumi hu nsasensɛm ɛbɛba abɛɛkɔ court yi, obi gyina a witness box mu na obi yɛbisa wo sɛ na wo wadi 25 nti 1990 a yɛyɛ document wo na wadi ahe. Ɛhɔ a na asɛm na ɛsɛ dɛn na yɛde bɛwie ane judge didn't issue so beka sampa. Sena mrati as at that time now you were not of full age. It's about much more your documents mana. Make sure they are either 18 and no the mrasi one bait me then it's in team krataso. And yes sir, do it in trust for them. Sina be omo do 18 na they fade am I then asasina be omo dear. Share section 38 so 3 subsection 3 now. Na me feel say interesting na me pese mo de madwin betie ho kakra na yetimi abobo mu kakra. Was in a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance unless a contrary intention is expressed in the conveyance. I'll repeat that section. or say, in a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance unless a contrary intention is expressed in the conveyance. May I add this subsection 4 no na ife yetimi discuss kakra. Where contrary to subsection 3, a conveyance is made to only one spouse, that spouse shall be presumed to be holding the land or interest in the land in trust for the spouses unless a contrary intention is expressed in the conveyance. Enti emi say na emra ne ka wo ha ne say awarefo ewo aware ase a na omo koje asase a sebe oko hene ho oko family head ho na tue sika ekoje asase na emra say ese mo bomu na makoye den makoje asase no nti mumienu ina emfa ho say bema ne nko ensa ne hye krata na se ana oba ne nko ensa ne hye krata na se mane say ye fa ne say munina asase na eden eye modea if you say it was acquired jointly during the marriage. Let me say at an earlier discussion they can say especially Ghana Supreme Court and I think it's even worldwide say a ordinance marriage and say Ghana e can no wedding and na akọ sign e wo court na enye efia ware na ejapade especially asase ne ndan no emma e ka say eye okunu ne oyere dia emfa ho say obema ne nko okunu ne nko din na ehya ase anase oba ne nko din na ehya ase sa na embra no eden ehwe ne ne na o cha ase enso say se wudi nko na ehya ase a ye fa no mbre mu say wo hwe so e de ama wo ho kafo no wo hwe so. Let me say as we go further in the law no mana ahihye po say wuntimi nton a wukunu ana wo yiri enim ho bi em say yedru ho na yebebobo amnusu mu ekakra na maka say ye court pon e wo Ghana no ahye mra ana say what make decisions say empempi no ebi wo ho a awaregyae ba divorce cases na de ba akotimi ka say oh we de ni sika kra enim edan na misiye na edan esase na metoy no ni sika bi enim na me de to asase no minkwa ma ho den ana minkwa madwuma me ye na etimi ma me ye den to asase ya na misi dan no court ne hwe ni say sebe wo koba no wo kra say miri ana mikunu me kwa aba sebe me ko first know mu akoye adwumaden me ko akohwe we me ko akoye we aba no na oba na so be ma na waje na ofie no no eden hwe fie no de ama wo enkola wo ho a na oba mo ho ban sebe oba na waye teacher ohwe fie aduane ne anu esi ho ama nti wo beba no na wo aba asomdwe mu akoye adwuma ama sebe ye de waduane esi table so emra no ana Ghana mratiti in the Supreme Court na am making various pronouncements cases mu say ni na eye emwa wo ho kafo na ede ma wo bra wo akọ pe sika putuo ede aba beboa no ni na ye mwa ni na ye ahoden ana contribution emwa na so no nso ne chefa ewo mu ni ono de na hoden boaye wo fie na wo so do nyansan na ho de ekope sika na ede baaye entu ntimi nka se wo yire kra na saa time no onye adwuma ampa obetimi prove so onye adwuma but emra na kire se no oye adwuma bi ana no oboa wo kwan bi so wo fie entu ntimi enyi ne ntwene saa se mewi ana mekunu de ono japade ye nya ye bra ya ware no ono ne de enka ho ana ne chefeni Enti awaregya yɛ ba mmara no bɛ ne hyɛ ne sɛ anaa court bɛhyɛ sɛ ne kyɛfa ɛwɔ mu enti ɛsɛ sɛ ɛyɛ dɛn wuyi saa ne kyɛfa no yɛ dɛn ɛde ɛma no enti mepamkyɛw wei deɛ mommɛntɔ yi nyinaa yɛ asomdwie hu sɛ saa na mmara no ɛka sesei ni na ɛne sɛ yɛka valuable consideration ɛsɛ mutua bibi enti ebi a ɔbaa anaasɛ ɔbɛrima no wabusua mu agyapadie bi abɛtɔ na yɛ kyikyɛ a ɛno deɛ ɛne sɛ ɛnka valuable consideration no because ɛno deɛ ade a yɛ wunyaayɛ efi wo wabusua mu entia anaasɛ ebi a bibi na akɔyɛ na obi de akyɛw a ɛne deɛ wo nko a wo dea ana wo nko a wo kwan sɛ otimi ka sɛ wei deɛ sɛbe ɛnyɛ yɛ mmienu ahoɔden ana yɛ nsusui ana yɛ nka bom a yɛyɛ sɛ okunu ne yɛyere na ɛma menya asase ɛyɛ menya asase fi sɛ mefi aso na ebusua mu ana sɛ mefi atagye mfi ebusua mu na yɛ papa agyapadeɛ no me kyɛfa ɛwɔ mu na yɛde ama me ɛm sɛ saa nteaseɛ no ɛba ɛbɛboa bebree nti mo yɛnhyɛ ne so sɛ sesei deɛ mmara no edi ama yɛn nyinaa ɔbaa na bɛrima o edi ama yɛn nyinaa sɛ yɛwɔ aware ase na yɛnya agyapadeɛ a ɛkɔ ɛde ma ɔyere ne ɔyere ne okunu nyinaa wodin wɔ mu o wodin ni so koraa mmara ne sɛ yɛfa ne sɛ mo nyinaa ɛyɛ mo dea ɛnyɛ na ne din wɔ mu no nko a na ɛne dea mmara mu no ɛyɛ mo nyinaa mo dea na sɛ onipa koro a ne din wɔ mu no ɔhwɛ so ama onipa koro a ɔno nso ne din wɔ mu no efi sɛ bra a maware no na moyɛ den motimi nya saa agyapadeɛ no pamutwo pii sɛ na mekaeɛ no contribution bi wɔ mu a pamutwo motimi call in anaasɛ you mute your mic and then you can also contribute to the discussion. I'm sure there are people who are viewing and say they can contribute to this discussion. Since it will be very good to hear from you. Okay. Until then, I think we'll continue with our discussions. And I'm reading a provision which relates to say the asase ama ubi. Nti me kind of protocol mu na me wi na ya bobo mu ewo hwikase mu kakra. Or say an interest in land may be conveyed by a person to be held jointly by that person with another person in the same manner as the interest may be conveyed by that person to another person. Let me say person and also. Mamisan came you. An interest in land may be conveyed by a person to be held jointly by that person with another person may be conveyed by that person
Okay.
issue kakra. Okay, let me say we are back on air. And terms say kakra we ne kan say wo ni wunua ana obi betimi enya asase e de abom na wo wa asase ni mu no etese na obetimi de ama onipa kro no enti mefa ne say mo age asase ebia 50 years na mu na modin na wo so no emra ne ma ne say Mpacho bibia you okay?
Yeah, koso.
Okay, thank you. Interest be was it could be the same, so we'll convey to another person. So you can acquire the same interest. And then 2 says a person may in one capacity convey an interest in land to be held in a different capacity by that same person. So section 2 here very relevant to us. Ebi wo hɔ na wona where the will mu no wona we executor na at the same time so we a beneficiary. Mmara na eka say in one capacity a we executor no wobetumi ayɛ den de asase na ma wankasa wo ho bio as what a beneficiary. And in one capacity you were the executor and now ebia administrator. In another capacity no we a beneficiary. Wobetumi ayɛ den de assign de asase na ayɛ den ama wa ho. And your signature may appear twice. Once as the executor or administrator, and then secondly as the beneficiary of the what? The estate. And now say ebi wo hɔ a oba na say bema wa wona asase no wodin wo so. Wopɛ sɛ wode wo din ka ho ana wopɛ sɛ wode wo kunu edin ka ho. Mmara no ma kwan ho kwan sɛ ɔbɛrima na sɛ ɔbaa na asase ne de ne din da krataa no so no ɔde agyapa no de ma ɔno ne ho bio ne wo a woyɛ ne yere anaa woyɛ ne kunu. Nti first no na asase no ɛyɛ ɔno nko ane dea. But say de asase no ɛyɛ ɔno ne wo ne yere anaa ne kunu no dea. So in one capacity he was a grantor, but in another capacity no ɔyɛ den grantee ɛwɔ property no so. And in one capacity no ɔyɛ lessor. Another capacity no he can be the lessee of it. So no no say okay me na asase me dia say me ka say me ne me yere dea. And bibisa. And this is what I think is relevant for us. It may be good for us to take note of. And at 3 is 2 or more persons may convey property vested in them to any one of them or more of themselves in the same manner that they can convey that property to a third person. And say na make an be an property na mo no nipa mienu ana miensa dia. Mmara ne say nipa mienu ana miensa etimi bom de ejapade no de ma nipa baako ewo omo sena omo miensa nyina betimi abom so ombeka say okay sise de ye ton asase ne de ama kwesi mensa. Nti saa na nipa mienu ana miensa omo din ehye krataa na ase no na omo din wo document ma no omo tintim krataa no omo anso betimi aka say ye miensa ye a meme ka ho no ye de asase na eden ma me. Nti in one breath no the person is like I said no or a grantor because na asase na bia ne papa de ma omo miensa nyina na say no nti ase aba no so okay sisi ye de asase na ma eden wo nko a ye de asase na ma wo nko a omutimi etintim krataa ma wa obesan ne bi say na first na asase ye de ma o papa de ma mo miensa na efe de sisi de ye de ma wo nko a. The law make provision say mo betimi aye no esa. Enti ye tria so me pa mo cho say na ye kan no bi ase bi wo mu a e pese ehu ana say enkomo bi wo ho a me pese ebo a just come in and let us also hear your views or have your questions. Okay, may kind something relevant to what we just discussed about spouses and our phone. Except as provided so section is here in section 38. In the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, rights or interest in land acquired for valuable consideration during marriage, A. Sell, exchange, transfer, mortgage, or lease the land, right or interest in the land. B. Enter into a contract for the sale, exchange, transfer, mortgage, or lease of the land, right or interest in the land. C. Give away the land, right or interest in the land inter vivos. D. Enter into any other transaction in relation to the land, right or interest in the land, without the written consent of the other spouse, which consent shall not be unreasonably withheld. enti ahano let me say the law has clarified it further the way property is to be held or dealt with between a husband and a wife or between spouses. Enti emi say yebehwe se na ebetimi atwere ase kakra kakra ewo ne akan no ho. Se na yaka deda no o say se mu mienu ana bra maware na mode mama hoden munyansa muntoboa ayede akogye ajapade whilst marriage na property na mwanya no nipa baako enko a entimi enton entimi entransfer ontimi mfa nkoma bank ana mfa nkosi awawa ana seden only see ana interest wo mu no odi bi ma obi ana say obe enter into a contract for sale exchange as a obe kaso or kwako o gina so akoton asase no ana say o gina so ai den a transfer ana say o gina so ai say otiasi or the way che obi in survivors ni che say otiasi is a Latin word as a motiasi in survivors was alive no nipa ba ko den obi de koma ana say wa obekwa akoye nhihye bi ewo asase ne ho who kafo all my written consent. This is the letter of the law. And yes, wafo so ewo dem so mikunu ana mere enye eye say hie sika and I say adwuma ye kwa akoye no o de fa kwa akoji loan no ana say ton bi ana say lease bi enye ano na say say edeka e mra ne say den yesisi e tro wo ho kafo no ese so otro say wa ma ho kwan say asase no ton ana fa kosi awawa ana se fa koji loan ana se fa ye nhihye bi ebe den ebe ma ejapade ne se na na etie eyemu mienu dia no eso ate emma ne kire se se no entisia implementation of this law the abia na ebe ya dia emma ne be kire se na ebe no ebi say it means say ya nye de bia na aware ne se na enim no Ghana hanom and I say in a lot of African countries, no, if you want a customary marriage, now customary marriage, so it makes room for 2 or 3 wives. Let me say, women's rights. Here, best say, because I say, the ben I used to 2 or 3 husbands. Openyi, I'm said that we bank it a home way who say, and then I'm running my whole coin say, or back to me, or met me 2 or 3 wives. No, bad, you own to me 2 or 3 husbands. Please, that is on the lighter side of it.
Next time.
Ghana mra ema ho kwan se obema timi ware mienu ana miensa ana sa nan ana so nipa kro na ekremoni a ne som no ma ne ho kwan so timi ware mienu miensa no and then na me chere say consent no oje fi hwan ho oje fi zinabu ho no oje fi anti Maria ho asna waje ho haje ho ana waje ho we so ana memuna na say we ho ana it's not say na mana eden I mienu miensa enan obeje written consent na free omo miensa na ho na ebe den po na say be register bit in office obehu say signature ya true say be no correct. I mean, so I think the airline and say man be bobo mu kakra se na be betimi ehu say ebia ese say we marriage certificate ba na no marriage certificate na be e be share signature kro enti en de oba no na oba be register so obi afa marriage certificate nkan if say man pese ye ne say be say maware a en de na tumi ni nipa ba konko ansem say obeden obetimi ayede aton ejapade bi ana bisa. Those viewing on Zoom and those listening to us, you are live on VitalGh Radio. And I'm coming to you from Accra, but we are broadcasting from the studios in Delaware, Middletown. And we hope you are enjoying our discussion. I am Joyce Atajemfi. And as I've introduced myself some time ago, I'm a lawyer who specializes in land issues. So if you have any land issue, if there are any questions, there are things you would want to know about land issues in Ghana, just feel free to do that. Get in contact and we can take the discussions further. Am I getting a contribution from somebody?
More was obetimi use the chat room no. So person will send in a text message obetimi use ono obehu. Ede obia more Facebook or YouTube or you know obetimi
Other
use
channels.
other channels now will be or her no channel. Say Facebook or no YouTube Twitch Periscope or whatever no. Obetimi use chat room no.
Okay.
So yeah, ono uye pepe ubehu nti no
It's
nya
okay.
dia ubehu o chat room ho then
It's
ni
okay.
na so ha nti do be a person we use no wait me use chat room so on person because one was no be also so but e bia na no tie no afamu adwen nti wo de ekoso so be person ya ono abepeja nsa na obekasa
Okay. I think the discussions would be more interesting if we have other people contributing to.
me question back na me wo na me pese me hu ne se na wo kan se asase no se say government na law I want to buy no that means say ebia me wa next question ne say obi was asase wa engran what nipa kuno fa no say from generation to generation na no want is asase no so ya be 200 years want to so ti does it affect them?
So be about the freehold and
Yeah.
freehold and leasehold.
Uh-huh.
Okay, that's a good question. That's a good question. Yeah, Emma in Sunsoin be makes a difference. Say, ufi ebusuani mu na ebusuani ejapade a in English they say indigene. You are indigene of the place. You have by rights a right use of the land. Say wo free baby fan say me free Ghana nti mama ho kwan say metimi de ma hoɔden ekodo baby a ebia na me grandfather ana me na kan so ebi na ɔwɔ asase a ɛno no enye leasehold na mekɔ akɔgye wo ho as obi a me indigene of that particular area no and then this law makes provision for it to say utimi ekɔ eden enya interest wɔ asase ni mu a sɛbe wonkɔ nhyɛ da nkɔka kyerɛ ɔhene sɛ mame bi ansa na ɔhene no aka sɛ mema wo anaasɛ memma wo na ɛno no borɔfo no ɔmɔka no usufructory rights usufruct nti the root word is use. You have the right to use the land nti sɛ yɛ mo nananom dea na ya pass on through the generations yes ɛno no wotumi nya freehold interest no because that is what has been passed on and that is the usufruct wo use but sɛ panyin wo na wo say no wo ton dea wontumi nka sɛ me wɔ freehold interest me usufructory right no for the use of the land as an indigene no nti me nso me pass on ama wo freehold ɛno na mbra no ɛden etwa so but sɛ wo so oba ɛba abɛdɔ asase no ɛde ba bɛyɛ use use asase na ɛmama ho kwan sɛ because sɛ ɔyɛ indigene no otumi nya saa freehold no interest no ɛwɔ mu a ɛkyerɛ sɛ ɔnkɔ ɔhene bi hɔ sɛbe ansa na wakɔ akɔpa ne kyɛw sɛ mame bi ansa na obi aka sɛ memma wo but sɛ ahanom nyinaa na ebi nim sɛ ebi a na ɛyɛ saa akafoɔ abusua asase a wowɔ ho kwan sɛ ɔbɛyɛ dɛn na wahoɔden betumi adɔ anaasɛ baabi a onim sɛ wɔ ha de obiara ndɔ hɔ obiara nyɛ adwuma wɔ hɔ no wotumi kɔ na nso kɔyɛ adwuma wɔ so na ɛyɛ dɛn mma ne wɔ nananom ɛbɛyɛ ɔmo nso ɔmo deɛ ɔmo dea sɛ yɛhwɛ a Say in America, if those, because we are in America, we are broadcasting in America. We sure first and call omo buy no no tete mponano. Georgia, New Jersey, omo tete mponano. Na kakra. Omo ye den hu so omo ho den eba no. No mo other state kakra baby omo ho odin bedru ye no and the nkofo mo koto ye wo ho no omo mutimi omo no mutena ye all the history around it omo mutimi tena but they acquired it into with time no omo ko de no omo ho odin timi ye den eje ye no omo koje ye into ho no de no omo peni papo because na ye de eye nwura na wo ho kwaya nkasa into na nipa ye peni papo aba be de abeboa na nipa aba be de abetena ho bi enti hono ba na wa ho de ntimi ye den edobia na ye den wo so aye wodia e ma nkrofo de chichiri kuro ma pempi no kura turo no ye de to nkrofo no Pennsylvania say no e obidin na ye de ato no Delaware Dupont na de say na ye obidin nkrofo agigi ye enti opanyi ma no ma ho kwan sa but wo se wo kwa akoton ana se wo se obi medema wo doso wo want me nka nche onipa kon say me tintim krata ama ema me ma o freehold interest in the land eno na mra no e ka sese mpacho nti ase na ba na
let's say me pese me koto asase wo mfan say ebru ho area na say mako hu ohene no na so hene ni twa asase bi ma me it means say assassin may be done for a certain period of time. Na assassin be on their back.
me fear obisa question me ka say brofo the word is indigene. Enti wo sese a wo kasa wo kwa abri no unye indigene of abri wo ye hoho
yeah and maybe some
okay we hoho dia emra no se na ti sese no esi da bi ohene ni hu kwan so be ma freehold enti ampa abri honom no kokofo edua ene a lot of other areas say no de no ma freehold enti na esebe na kama sebe ko je asase wo ha onye obi ni twaka bi ene say but say the emra no se me enye ne sa but because emra so enye retrospective no okoje asase no before the coming of the law na ye freeholder emra no enka se ebesesa no debi enti sa wo ona na bi na eje freehold interest na emra no makonkwan se ye be register ne say freehold especially what stamp because ebi o na man ye hwe ne say say date the obi etimi bobi nti ebi o pese you want to hide under the you want to escape I think the word to use is escape you want to escape the provision of freehold no nti ebi no akobo ne so asase mi to ne 1990 ebi wa na esri nkofo bi so moton sase 1990 ni 1980 eso na comb binding them say na that time na comb binding na ebi abagana na it is was an nkofo kwan bi to avoid or escape the provision as it is now so that is the understanding but so free kronimu dia we ebusua ne ba dia that is what the law says usufruct use you have the right to use the land as an indigene na HRC supo ewa ha ewo section American say in say where a lease in respect of bare land is granted by a person who holds an allodial or usufructuary interest word na use here usufructuary usufructuary interest in the land and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed the land for residential purposes, B, a farm or perennial crops on the land, or C, a commercial or industrial property on the land for the same duration as the original lease when the lease expires. And due to say, na ese na meka ni nipa bebre na tena ase na echichire emra no enti ye hwe ne ha ne ahwe ne ha enti utum se hwe ne se emma eya wemba land acquisition for leasehold say bia wakoje asase wakoje ne for 50 years mpempi no ya na leasehold covenants ni bi say renewal clause say ebia obetimi a review for another ebia 10 years for want of a better example. Instead they say na asase am abeto me na abeto me papa ato esidan why say was na 50 years na so o say den me ntimi renew bioma na enti ahana mra ne pese kire say ye dey asase ne ma na we indigene say na ye kekan kai no ewo ho and you have a right to automatic renewal. Automatic. Enti me feel say mra no ahana aboa bebre. Enti enye fe na akwa defe ohene na family head be o disika bebre akɔhye asase ni mu. Efe na akwa pa chew ohane list. You say where the lessee has developed the land for residential purposes, where Sidanya or them for residential purposes. 2, why a farm of perennial crops on the land. C, commercial or industrial property on the land, same duration as the original lease when the lease expires. Enti I had the embrana boa bibri because a beya de na de abobo kakra say na mabeto asase no won kran. It's 50-year lease, 60-year lease. And after that, what happens to me? Let me say the origin of all this renewal, and me say I know you may imagine because it means a time bruni at the leasehold and as she buy na sa time no omo do a tree e wo omo na se na etese wa broche no normal ukwa high dan na mpempi no ebi wo ho a na yesiesie mu ededa because say bibi ho na fridge wo gas wo ho na ade enso yen die se be asas no kwata no na wo de wa ho den kwa eden adwuma wo so enti eden na ka kire wo se ja leveko obroni de ne de fridge na obeto ye se be obeto fridge na something mean ka say uko no di fridge na eko obeto gas wo ho na ba beto wo nyina se be e de obeja ho na wako obeto ye but yen de ne de me se ntisa me se asase ne da ho pete na wo wa be den abe develop enti eden na utimi ka kire me se ahoden a me mama ne me papa di shemu me na aka nso no di shemu no ebe den ebe ekwa na wo ne wo ma aba abeje debi enokwa de se na mraka na equity and emma ho kwan sa enti me edanyame ase se emma no etime hwe ne sa ebe de ebeboa enti na enya enka akoma to ye mu se the law has provisions it seeks to protect all of us as citizens of the land. This is a great credit to the makers of the law. Aboa bebre. Say yemre no yako. Inti me pese me wie on the renewal clause no. Renewal no. Na ho nsem no na etimi dia eden e de awie e wa ha. Na minim se nka menya mpanyimfo bi manka ye di nkita ho kakra. But let me say either so mun yo monim ana say ebi omo ntimi and because of the timing here. But I hope say in subsequent discussions no yebenya nkrofo omo so munim de ekwa echi won sa asesem ho no ma beboaboa ye na ama ye kita ho na ye de kokan ana say ayede sense na TCC no. Okay, intimatua so provision ba ko me kan protocol sem na efe ma explain na efe de eja e de ama penye ando atua so. So unless otherwise expressly provided in the lease where bare land is leased to a citizen of Ghana who is not an indigene of the area where the land is situated, there shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. Unless otherwise expressly provided in the lease, where bare land is leased to a citizen of Ghana who is not an indigene of the area where the land is situated, there shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. Enti me se penyin se na obi sai no na no ne ba ko no na wo fi krom ho Ufi ebusuanim. Enti we are indigene. But it me who say dear, obi akọ baby ye ware so wo baby enti utimi nya ajapade wo baby wa hoden ebetimi aka edin hye no nko aso de a. Enti so long as we are citizen of Ghana no, mmara no so boa protect we say even though ebi wo ho kra na beka say yanchro no sa wo list mo kra. The law no be ye ne say it is implied and say onu for wani na ehu ana say ye fa pen ne nchro no sa, but humwe woman say you are entitled to a renewal. And I think it is right. Because if you are not entitled to a renewal, always sit down was what? Say me, who just die no? Now only woman will not know ako pray baby. I mean, I know the immediate say a man I dear because I know the can a very harsh, very harsh to be a citizen. Obroni kromu kra said utimi to dan etene mu freehold. Utu your mortgage we nko ade ya wo de a. Ene wa krom na efe na wo de wa ho den abesi dan efe de ese den. Mrase se na atro no no. Nti 50-year lease into automatically no your interest is extinguished and then can be very harsh and it would have led to a lot of social issues in the country in terms of provisional law ni mu de ne kwan so ani. And I think the last one you be and send be a say or say a lease of bare public land granted by the Republic to a citizen of Ghana is subject to automatic renewal on terms agreed upon by the parties. And then it makes some exceptions here. Subsection 12 does not apply where the lease is in respect of a commercial property or the leased property is required for redevelopment. Enti ahanso ye ka say once a we Ghana ni no say aban sa ase kra na ye de ma wa na ebe land na ye de ma wa, you have a right to automatic renewal on terms say the momo be say den agree amongst the two of you. Unless say bia lease na ye de ma won na commercial property and I say ye hwehwe asase for redevelopment. Na redevelopment na aban chere say ebi wo ho a otimi say we the abakosem kakra emi so omo a omani afi no na bi ombehu omhwe say some time ago Koforidua area no dem say baby wo ho a na nipa wo anem so mu ye nantwie na ade na em say kro no ekoto bibi omo ye say mfuo no no mo ye nantwie no em say eho no na no region who said that say the asase it is due for redevelopment. Inti emaye tu nkrofo ni na efri ho ema omo be de ebesi sisi adan ena ade de ewo ho. Otimi nso say pempi no ebi wo ho na government ankasa na agi asase bi for a certain project. But it means as the years went by no na as say area no abafom pa development wo ho ni na no timi say dan na chiche ebi wo ho na ebubu kra na ade eno de na aban no ne hihye mu no pese de oye redevelopment nti ebi wo ho na obese ebubu dan ni na kra no ma eden o ma no foforo nti ho ne de na ye ma o renewal because ye ba be adwuma foforo eden e wo asase no so, but no cross said on terms to be agreed upon by the parties. And I didn't tell me say emra emma nhyehyeye a emma ho kwan say saa ehu a na ewo mu anase abobo a ewo ho say na makoje asase me de minisi makoto asase na say normally so obi akwa akoto asase o kasa makoto asase. My understanding is that I bought land. I bought a piece of land. I wouldn't say what the akra. If you had the lease near brewa, the document near brewa, it's 50 years, 60 years. And that is within a lifetime. And after that, what happens? I hire safeguards law no so there. Be protected citizens of the land and we are indigents so now it's me and it's me here, you have a right to the use of it without necessarily going to see a chief or a family head and son idea esan se wo yo mabantino wo ho kwan se wo ye den wonso ewo. Okay, I think I've read the law and it's so, I think the understanding is coming that the law has sought to protect the interests of both citizens of the land and the other provisions too, even for non-citizens, that there is automatic renewal for lessees on land, even if it is not written in the instrument or in the lease agreement that you have. It is implied by law that you have a right to renewal. And that is comforting, because otherwise, properties that people have worked for to be able to acquire, it will be deemed that they lose that property, because you can get a lessor who will say that, no, I am not renewing it for you. And you may have to go to court to go and protect your rights. And you may get a judge who will look at the letter of the provisions and say that, yes, you signed for a 50-year lease. So if the chief or the family head says that I'm not renewing, then that means you have to pack bag and baggage and leave. That will be very onerous. So the law has tried to put in safeguards that will protect citizens of the land so that we can all enjoy our property rights. I think we've had some discussions, and we'll continue, God willing, next week. So this has been your presenter, Joyce Atajemfi. And like I said, my number on WhatsApp is 0264 257 030. 0264 257 030. So you can call, and like I said, we can take the discussions further. If you want to have a legal understanding, if you want to hire my services, if you want opinion, you can see how we can assist. On that note, I would want to wish everybody a fruitful weekend, all of us keeping hope alive. Hand over to Openyi. And Openyi, thank you very much
No.
for producing and for the program this evening.
You better was so as I said, next what me about joining. Or China so your program back when I started 7 o'clock. Into more mutie on YouTube now, more mutie on radio. So yeah, I'm joining. Na muntie the echoes will be brave or yeah, my Ghana. You know, thank you for watching, and join us tomorrow at 7 p.m. Thank you and good night.